If this is your first time on the channel and you want to know everything there is to know about living in Redondo Beach, California and the surrounding South Bay area, then hit subscribe so you can stay current in what's happening in Redondo Beach. My name is David Chou. I have lived in Redondo Beach for over 30 years and been a realtor for the last 20. Myself and my team at the Co-Real Estate Group, we love to help people navigate the move here to Redondo Beach. And whether that's 9 days or 900 days away for you, we would love to be connected with you. All of our contact info is in the description, and we'd be happy to help you make a smooth move to Redondo Beach or the South Bay area. Hey everyone, David Chou here. Welcome back to Living in the South Bay, where we talk about all things real estate related, both sellers, homeownership, buyers, investors. And today I've got a very interesting guest. Christine Chou here is an attorney. And, one of the things that we have a lot of here in the South Bay are boundary disputes, right? We're so dense. We got 200 lots and just small property sizes. And I know there's a lot of issues with people on who belongs to the wall and what happens with that. So instead of me guessing what to do, I figured I'd bring on an expert. Christine, thank you so much for being on the show today.
Thank you for having me, David. I'm really pleased to be able to share any kind of expertise that I might have, and we can talk about these survey and any real estate related issues. That's my area of practice. We also deal with construction defects, contractor owner disputes. So completely in my wheelhouse, and we can talk about these boundary disputes.
Yeah, I might want to get you back on to talk about SB 800 claims. That'll be for another day. Let's talk about boundary disputes. So, this happens a lot. Even properties that we sell, there's some gray area on who owns what wall and who's responsible for maintaining it. But I know you get a lot of that kind of stuff in litigation. So when someone comes up to you and says there's a dispute, what does that look like when you take that call for the first time?
Sure. So when I take that call for the first time, it's always going to start with me suggesting that they get a survey. You need to know where your boundaries are. And unfortunately, with all these older built homes, the wall kind of being near the boundary line is very, very common. And this has happened a lot. We've seen it a lot in Altadena, the Palisades with the recent fires, people trying to rebuild and getting their surveys. And so that is like the number one thing that I absolutely recommend. People don't like doing it because they're like, ooh, professional expense. Why do I have to spend X amount to do this? If you're wanting to preserve your property rights or not infringe on someone else's, your neighbor's property rights, you're going to want to know where that boundary line is. You're going to want to know that you're putting up a fence either on the line or within your property.
Yeah, man, surveys are, you think of a survey being a couple $100. They're not. They're thousands of dollars to get a good survey, even on a small piece of.
Yeah, and it is well worth the money because let me tell you, the amount that you're going to be spending to get back a few inches or say even 100 square feet along, from the front to the back of your property line because of a misplaced boundary wall, it's costly to get an attorney. And the thing is, you have homeowners who are like, well, I'm paying property tax for my property that's on the other side of this fence or wall. Right. And so that's why it's important to know where you are placing any boundary, hedge, fence, wall, all of that applies here. You're going to want to know where in relation to that boundary line, it's all going to be situated. And the only person that can really do that is a licensed surveyor.
It's also like if I wanted to add an ADU, I know there's so much about not just the placement of it. It might be on my property, but there may be setback. And if I don't have enough of if I don't know where the line is, I don't know where that structure should go. And that could put me in conflict with the neighbor.
That's absolutely correct. And the setback requirement is not from the placement of a fence, but actually from the boundary line, right? So you know about that. And you're going to want to make sure that your setbacks are right. Otherwise, you get through a certain part, maybe you've trenched or done some initial stages to lay that foundation for ADU. You might have to move it a couple inches over, and that's just money and time. So again, that survey is really important.
All right, so let's say I have the survey. I find out whatever information the survey gives to me. I want to build a fence. I approach my neighbor. They're not open for it. Or maybe I get a survey and realize the neighbor has a fence that's encroaching on my property. How do you get involved and how do you help when there is a conflict like that with another neighbor?
Yeah, so if this is kind of like a building the fence type issue, sometimes we do see encroachment issues where someone needs to move a structure or we figure out some kind of easement arrangement. But usually if it's pertaining to the placement of a wall, that survey is really going to guide what your rights or my client's rights and responsibilities are. Do they need to build a fence? If you cannot get your neighbor to share the cost of building that fence. And these are not cheap. It depends how long it is. If you're talking about like a brick wall, those concrete masonry ones, those are quite expensive. Here's the thing, you cannot force your neighbor to pay for 50% of that. Usually people ask, hey, do you want to split the cost? This wall is going to be mutually beneficial to both of us. But again, and I've seen it. I've actually had a call today regarding this very issue. And the neighbor is like, no, I'm not going to pay that. Then what's the alternative? Well, you know where the boundary line is. You can build your wall and you pay for 100% of that cost, but you build it within your boundary. And that's it's unfortunate because your neighbor clearly benefits from having whether it's privacy or, keeping their things on their property. But at the end of the day, you're not going to be able to force your neighbor. The issues arise primarily when there's already a pre-existing wall or fence and there's either damage to it and needs replacement, or the situation that you brought up, you have an ADU or some kind of construction project. You do that survey and you figure out, oh my gosh, this wall that's been here for how long is actually not on the boundary line. And that's where it's like, ooh, what do we do and how do we proceed at that point?
So to sum it up, like if the wall is on a boundary line, then we're both responsible, 50-50 on each side.
Yes.
But if the wall's on this side or that side of the boundary line, that will determine who's responsible for maintaining it, for paying for it. And you don't know that unless you have a survey.
Correct. Absolutely.
Yeah. What other kind of nuisances do you deal with between neighbors? I know most neighbors get along. We get along great with our neighbors, but there certainly are disputes. What are the types of things do you see and how do you advise people?
I don't particularly like taking on neighbor dispute cases because it gets touchy. I mean, people's greatest investment, which is their home, or even if they're renting, it's still very costly. Issues arise when they feel like there's some kind of violation of privacy. And so I've seen it where don't point your security camera into my house or into my yard. There's privacy concerns. And so it gets really touchy. I try not to touch these types of cases, but these issues arise. And so it can be difficult to navigate. Because once an attorney gets involved and you send a cease and desist or point your security camera somewhere else, you kind of generate those hard feelings and that feeling of distrust between neighbors.
Is that usually the first step, though? Send a letter and just see if the letter can help find a resolution?
Yeah, but I typically advise my clients that, look, getting an attorney involved from the outset kind of escalates things just simply because there's an attorney involved. If you want to try to settle things informally or approach it from that kind of more neighborly perspective, maybe a letter just to document or have a paper trail from the client themselves. But if they feel like it's necessary to do a cease and desist because it's a serious thing, or maybe they're not so neighborly, maybe it's contentious, then I do recommend a letter from an attorney. But if you can always avoid hiring an attorney, I push people that way. And I say, come to me after you get the survey or come to me after it blows up. Because it gets so expensive for people.
I know one thing you're really busy with, and it's really prevalent right now, is title fraud, where people are just randomly putting, quitclaim deeds on people's properties. Talk about that.
I don't know if it's the notaries that are also their stamps are being fraudulently used, but we're seeing this pretty commonly right now, where I have a recent case where a client found out because they got a notice from the county recorder that a grant deed with her signature was forged, granting her property to herself and another single man. No clue who the single man is. And she's like, what is this? It's a cloud on title though. And the thing is, it may look legit. Even if you were to compare, the signatures are different, etc., from the previous deed. The problem with this though is, we talk about cost of ownership. No one's going to factor in, I got to hire an attorney to clear up my title. This is a really difficult thing to navigate because you don't always have someone on the other side. How do you clear this up? It comes in the form of reporting the fraud, letting the county assessor know so that they're aware of it. But as soon as possible, you're going to want to file that lawsuit. Why? So that you can put a lis pendens on the property. That will prevent being able to transfer anything like that. So in the case that I just mentioned, there was a fraudulent grant deed and then a quitclaim from my client to this unknown person. And to me, it's insane because these people are strangers. You have no idea who's doing this to your property. I mean, if I wanted to, could look up your property and let me just file some weird grant deed on there. Even if it was found to be fraudulent, what a pain for you to have to hire someone now to pay an attorney to clear this up and quiet title.
How long does it usually take to get a quiet title action?
To get something filed immediately, I mean, you can do that within a week or 2 weeks. That's going to be what you do to get that lis pendens on. But in terms of getting this and seeing this through to getting a court judgment to quiet the title, I mean, I wouldn't even be able to say. It could be a year, it could be 2 years. It depends on, the court's docket.
So if I go to sell my property and all of a sudden there's some random second, third trustee, even though it's completely bogus, I'm not going to be able to sell my property until I get that off the title report.
That is correct.
So as homeowners, what do we do? How do we find out about this before we're ready to sell to keep the property?
I believe all local assessors, I know LA County has this, you can sign up for alerts regarding your own property. Mm-hmm. And so any changes that are made to your title, you will be sent some kind of notice in the mail. And I recommend this for every homeowner. I mean, even as professionals, we're like, oh, we know what we're doing, but we don't always take the necessary precautions and steps for ourselves. Highly, highly recommend, because this is your most valuable asset. And, most people have loans, things like that.
Yeah, and look, if it does happen, you'd rather have it happen when you're not trying to sell and you can address it, and then versus when you are trying to sell. Sometimes I would bet these things happen, people don't even know until the prelim comes out, and then everyone's sitting there scratching their head trying to figure it out, and that sale is gone, and who knows.
For sure. You see this with SFRs. You also see this kind of commonly with those lots that are out in San Bernardino or Riverside and not really paid attention to because they're just kind of holding on to it for appreciation value and things like that. And so it's important. And I recommend, even without the alerts, just check title every now and again. It doesn't hurt.
So yeah, if you're seeing this and you're curious about it, and you can absolutely check the assessor or let me know. I have great title reps who would absolutely pull a prelim and just make sure that your title is clean. But if for some reason it isn't, please contact Christine. This is what she does. Her contact information will be below and she can help you solve it. Christine, thank you so much for taking some time out today on these two issues. We'll have your contact information below if someone wants to get in contact with you. But thanks for joining today.
Absolutely. Thanks for having me, David.
All right, and thanks for joining. Again, if you like this video, please hit like. If you haven't yet, please hit the subscribe button below. We're going to bring great content again soon. We'll see you next time.